Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 145 subsection 3, where the assessing officer has a power to reject the books of accounts if there are discrepancies in the books of accounts of the assessee and then estimating the income of the assessee. The present issue in the case was that if by the appreciation of the facts of the case, both CIT appeal and tribunal tax the rate of the gross profit of the assessee at 2%, which was taken by the assessing officer at 4%, then whether the revenue can challenge this rate of 2% just on the basis that the assessee has shown a higher gross profit rate of 3.25% in the subsequent year, or in other words, whether the rate should be 2% or 3%, whether it is a question of fact or whether it is a substantial question of law. This issue has been taken up by Honorable Gujrat High Court in the case of Principal Commissioner of Income Tax versus BB Tradelink Agro Pvt Limited, and this case is reported in 483 ITR at page number 232, and the date of the judgment is 11th September 2023. In the present case, the relevant assessment year is 1213. The assessee is in the business of agriculture commodities. There was a search under section 132 in the group companies of wage to which the assessee belonged. Since there was search, so the assessment of the assessee becomes mandatory under section 153A. So accordingly, the notices were sent to the assessee. And when the assessment proceedings were going on, the learned assessing officer found some defects into the books of accounts of the assessee, and accordingly he made a viewpoint that the books of the assessee should be rejected under section 145 subsection 3, and by rejecting the books of accounts of the assessee, the assessing officer observed that in the previous year, which is relevant to the assessment year 1213, the gross profit rate is 1.09% and the gross profit rate for the subsequent year was 3.25%. So the assessing officer arbitrarily take a gross profit rate of 4% in the relevant assessment year. If the assessing officer have taken the average of the two rates, then even then the gross profit rate taken by the assessing officer was much higher. The main observation of the learned assessing officer during the assessment proceedings was that during the previous year relevant to the assessment year 1213, the total purchases of the assessee were 182.95 crore, and out of that total purchases, the purchases from unregistered dealers were 118.54. So he was suspicious about that why the assessee was doing such a big amount of purchases from unregistered dealers. Perhaps it may be the case of the assessee that since the assessee is dealing in agriculture commodities, so a lot of purchases should have been from the unregistered dealers. But the assessing officer took the rate of 4% of the GP. When the assessee filed the appeal before the CIT appeal, the CIT appeal party allowed the appeal of the assessee and took the gross profit rate of 2%. When this matter was before the tribunal also concurred with the view of the CIT appeal and took the rate of addition of gross profit at rate of 2%. The revenue challenged the order of the tribunal mainly on the ground that since the gross profit rate of the assessee in the subsequent year is much higher, that is 3.25%, so there should be some increase in the gross profit rate. But when this matter was heard by Honorable Gujrat High Court, the court was of the opinion that determination of the rate of the gross profit is a question of fact and it is not a substantial question of law. Hence, whatever the order has been passed by the tribunal by confirming the order of the CIT appeal, that is justified, and declined to entertain the appeal of the revenue. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus BB Tradelink Agro Pvt Limited, and this case is reported in 483 ITR at page number 232, and the date of the judgment is 11th September 2023. Thank you, friends.